Criminal law is the body of laws that prohibit and punish acts that injure people, property, and society as a whole. First, we need to define what is a crime. A crime is an act or omission of an act that is prohibited and punishable by federal law. Criminal law serves a number of purposes: to protect people and property, to maintain order and preserve standards of life, to discourage potential offenders, and to punish and/or rehabilitate. We have the definition of a crime, but what is a crime? A crime depends on the morals and the values of society. The Law Reform Commission says to be a crime, the act must be considered wrong. The act must cause harm to society or to those who need protection. The harm must be serious. The remedy must be dealt with by the criminal justice system. Crime is caused by many things. Some of the possible causes could be poverty, a disregard for others' rights and property, drug use, insanity, anger, revenge, but there are many other causes as well. The federal government has jurisdiction over criminal law, so all provinces have a uniform criminal law. Laws passed by the provinces or municipalities are called quasi-criminal. For example, the Motor Vehicle Act. It varies from province to province. The federal government makes and revises criminal law, but the federal and provincial governments share the administration of the law. There are a number of federal statutes that cover criminal law. There's the Criminal Code, which was passed in 1892, the Youth Criminal Justice Act, Controlled Drugs and Substances Act, Food and Drug Act, Income Tax Act, and Customs Act. These are acts that have been passed by our federal government. Our Parliament can change the criminal law at any time. They may decide to make certain actions criminal. Why would they do this? Times change, and interest groups can oppose certain existing laws. The values of society change. For example, laws against drugs, guns, drunk driving, capital punishment, and abortion. All of these are up for debate at any time in our Parliament. Under criminal law, we have to understand the idea of intent. There might be general intent and specific intent. General intent is the desire to commit a wrongful act with no other motive or purpose. For example, an assault is committed. There might be a specific intent. That is, the desire to commit one wrongful act for the sake of doing another. That is, an assault occurs, but the real purpose was theft. Liability is the legal responsibility for a wrongful action. There are two types of liability. To be convicted of an ordinary crime, a person must not only have committed a criminal action, but also have a deliberate intention or guilty mind, mens rea. In a crime of strict criminal liability or absolute liability, a person could be guilty even if there was no intention to commit a crime. The difference between strict and absolute liability is whether the defense of a mistake of fact is available. In the crime of absolute liability, a mistake of fact is not a defense.